All right, good morning. Are we ready to go?
We are, Your Honor. Thank you for your patience.
Sure. We have an interpreter matter first, Rhea Garcia.
And Your Honor, just for the record, I believe there are two interpreter matters.
Oh, you're right.
Thank you.
All right, what does the state feels appropriate on the center?
La fiscalía que piensa que es apropiado en este caso.
You're muted, Mr. Reichenberg.
Yes, Your Honor. So first, I would note that we tried to reach the victim, but have not been able to.
Primero que nada, quiero decirles que hemos tratado de ubicar a la víctima, pero no hemos podido.
But we are prepared to go forward.
Pero estamos listos para proceder.
Based on the facts of this case, we are asking for $15,000 bondable only.
Basado en los hechos de este caso, estamos pidiendo $15,000 fiables nada más.
And that is because it's the category B with a human victim.
Y porque es un delito de categoría B con una víctima, un ser humano.
And we are asking for DAS supervision as well as no weapons.
Pedimos supervisión por el Departamento de Justicia Alternativa y no puede tener armas.
And stay in Northern Nevada.
Y se tiene que permanecer en el norte de Nevada.
No contact with Mr. Rolando Gonzalez pursuant to NRS 178.
No puede tener contacto con el señor Rolando González de acuerdo a la ley 178.
The defendant has limited history, but not in the state of Nevada.
El acusado tiene antecedentes muy limitados, pero no en el estado de Nevada.
I show that he has an alien inadmissibility in Eagle Pass, Texas in 2023.
Muestro que tuvo un delito de ser un extranjero no admisible de Eagle Pass, Texas en el 2023.
And then I show a felony arrest for grand theft auto in Miami Beach in 2024.
Y un arresto por delito grave por hurto mayor de un vehículo en Miami Beach en el 2024.
It looks to me like the state of Florida declined to proceed with the prosecution in that case.
Parece que el estado de Florida se rehusó a proceder con la acción judicial en ese caso.
Also concerning, though, given the things that are contained in the PC sheet regarding the victim having news stories of the defendant involved in crimes out of the country.
Y también nos preocupa cosas contenidas en la ficha de motivo fundado en que la víctima dijo que tenía algunas cosas de decir acerca del acusado y los delitos que está involucrado fuera del país.
And so based upon that, we believe that he's a risk not to appear and a risk to this victim in particular.
Y basado en todo eso, decimos que él es un riesgo de no comparecer y es un riesgo, un peligro para la víctima en este caso también.
And if I didn't ask, I apologize. No weapons, and then I'd submit it.
Y si no lo dije antes, él no puede tener armas y con eso se lo presentó al tribunal.
Defense?
Thank you, Your Honor. Your Honor, I didn't hear information from the state that would reach the clear and convincing standard under Padilla. Nope. Under Valdez Jimenez.
Su señoría, gracias. No he escuchado información de la fiscalía que llegue a decir que esto surge al nivel de ser un estándar bajo la causa de Valdez Jiménez.
In this case, looking at the risk assessment of the 10 score, 4 of them have been moderated through our investigation.
En la evaluación de riesgo de reincidencia del factor de 10 máximo que podía tener, 4 han sido ya moderados a través de nuestros investigadores.
We were able to speak with the wife in this case, Paula. She was able to confirm the following.
Pudimos hablar con su esposa en este caso, Paula, la cual pudo confirmar lo siguiente.
There is a confirmed address at 3030 Leadership Parkway.
Hay una dirección confirmada en el 3030 Leadership Parkway.
With a prior address in the county since April 15th.
Con otra dirección anterior en este mismo condado desde abril del 2015.
He had been working at KFC for 2 years and now works for DoorDash.
Él había estado trabajando para KFC durante 2 años y ahora trabaja para DoorDash.
He does have a cell phone, which number is listed on the NPRA.
Él tiene un número de teléfono que está indicado en la evaluación de riesgo de reincidencia.
Therefore, we would ask that an OR be granted in this case with all other conditions outlined by the state in place.
Así que pedimos que le dejen salir bajo palabra en este caso y que impongan las condiciones que la Fiscalía detalló anteriormente.
While this may be a moot point because of any ICE hold potential or in the past,
Quizás esto sea un punto mudo porque la retención que tiene o que ha tenido en el pasado con ICE
I would argue that it does not change the analysis under this court for Valdez Jimenez.
no
On that,
cambia, no cambia en análisis ante el tribunal bajo la jurisprudencia de Valdez Jiménez.
So I disagree on that last point.
Eso último que ha mencionado no estoy de acuerdo.
The state has two compelling interests involved here.
La Fiscalía tiene 2 intereses obligatorios en este caso.
One is ensuring the safety of the community.
Uno es asegurar que la comunidad se mantenga a salvo
And the facts of the case pose serious issues in that regard.
y los hechos del caso me hacen que tenga dudas serias en lo que se refiere a eso.
The second compelling interest is ensuring the defendant is held accountable for the crime.
El segundo interés obligatorio es asegurarnos que el acusado sea responsable o se le haga responsable por el delito.
And if the federal government is going to take the defendant and remove him,
Y si el gobierno federal va a llevarse al acusado y lo va a deportar,
then bail is necessary to ensure the state's compelling interest is honored.
la fianza en ese caso es necesaria para asegurarnos de que se van a honrar los intereses de la Fiscalía.
Now, we don't know the answer to that question,
Ahora no tenemos la respuesta a esa pregunta,
but given the defendant's criminal history
pero dado los antecedentes penales del acusado,
and the facts of this case,
los hechos en este caso,
I do believe the state has shown by clear and convincing evidence
creo que la Fiscalía ha mostrado a través de pruebas claras y contundentes
that bail is necessary
que la fianza es necesaria
to ensure the safety of the community and the appearance of the defendant.
para asegurar que la comunidad se mantiene a salvo y que el compareciente va a presentarse.
It'll be set as requested.
Y lo fijaremos tal y como se ha pedido.
No 10% option,
No tiene opción de pagar el 10%,
no contact and separate criminal offense pursuant to NRS 178.
no puede tener contacto en un otro caso criminal de acuerdo con la ley NRS 178.
It'll be for the maximum 120 days.
El tiempo va a ser un máximo de 120 días.
No firearms, check MVDAS is ordered.
No puede tener armas de fuego y tiene que presentarse ante el Departamento de Justicia Alternativa tal y como se le ordena.
Obey all laws, make all court appearances.
Tiene que obedecer todas las leyes y presentarse a todas las audiencias que tenga programada con el tribunal.
November 7th at 9 a.m. is the defendant's next court date.
El 7 de noviembre a las 9 de la mañana se celebrará su siguiente audiencia.
Ramirez and then Rivera Mitchell.
Ramírez, por favor. Your Honor, could I have Ramirez's case number, please?
Sure. RPC 2025 064414.
Thank you.
What does the state feels appropriate on this matter?
¿Qué es lo que la Fiscalía piensa que es apropiado en este caso?
Yes, Your Honor. In this case, we are asking for $200,000 bondable in the bail.
En este caso, su señoría, pedimos $200,000 de fianza fiables.
While we understand that he has no criminal history, he does have an immigration hold at this point.
Aunque entendemos que él no tiene antecedentes penales, en este momento él tiene una retención migratoria.
And in the state's view, the extremely large amount of heroin that was located both in the vehicle as well as the apartment poses an extreme risk to this community.
Y en nuestro caso, la cantidad tan grande de heroína que encontramos en su carro y su departamento hacen que esto sea un riesgo.
I would note that the methamphetamine at issue was also on a significant amount.
Y también quiero que tomen reconocimiento de que la cantidad de metanfetamina también era una cantidad muy alta.
It's clear that the value of the controlled substance at issue is a high amount and that this defendant poses a risk in the community with the sales indicative of that amount.
La cantidad, el valor de la cantidad que tenía nos hace pensar que él es un riesgo para la comunidad y que existe un riesgo de venta.
And that in the state's view, he's a flight risk given the relative lack of ties to the community and the serious penalties faced here.
Y en la vista, punto de vista de la fiscalía, corremos el riesgo de que se fugue, dado el hecho de que no tiene ninguna atadura o ninguna liga a la comunidad y es una penalidad muy severa la que se está enfrentando aquí.
With that, submit, Your Honor.
Con esto se lo presento a su señoría.
Thank you, defense.
Defensa.
Thank you, Your Honor. I believe that the state has shown that a monetary bail is required.
Gracias, su señoría. Creo que la fiscalía ya ha demostrado que necesitamos una cantidad monetaria de fianza.
I fundamentally disagree, however, with the amount and would ask that it be set at $10,000 bondable.
Pero fundamentalmente no estoy de acuerdo con la cantidad y pido que lo fijen en $10,000 fiable.
In this case, the NPRA shows the very bottom of a medium risk at number 5.
La escala de riesgo de reincidencia es a un nivel medio, ha tenido un resultado de 5.
There are connections to the community with his mother residing here and a local address.
Hay conexiones en la comunidad, su madre reside aquí, tiene una dirección local.
I believe that I could have conversations with the state and the court based on research into controlled buys and the use of CIs in terms of danger to the community.
Creo que podría tener una conversación con la Fiscalía y el Tribunal basado en investigaciones de compras de sustancias reguladas y el número de el uso de informantes escondidos y en lo que se refiere al peligro para la comunidad.
However, based on the NPRA score, I think the risk and dangerousness is assessed appropriately there, which is a verified tool.
Y basado en la escala de riesgo de reincidencia, creo que la evaluación de riesgo se ha hecho apropiadamente y es una herramienta que hemos verificado.
On that, I submit.
Con eso se lo presento.
State shown by clear and convincing evidence
La Fiscalía ha mostrado a través de pruebas claras y contundentes
the bail, even outside the defendant's ability to make it,
que la fianza está fuera de lo que pueda pagar el acusado.
is necessary to ensure the safety of the community
Es necesario esta fianza para asegurar la seguridad de la comunidad
and the appearance of the defendant.
y la comparecencia del acusado.
Therefore, it will be set at $100,000.
Por lo tanto, vamos a fijar la fianza en $100,000.
EAS supervision, obey all laws.
Tiene que obedecer todas las leyes y ser supervisado por el Departamento de Justicia Alternativa.
Make all court appearances November 7th at 9 a.m. is the next court date.
La siguiente audiencia es el 7 de noviembre a las 9 de la mañana. Tiene que presentarse en todas las audiencias que tenga programadas.
And Your Honor, that's bondable only?
Su
Yes,
señoría,
by administrative. Sorry.
¿es fiable la fianza? Sí.
Rivera Mitchell and then Connor. That's all the
Connor.
interpreter matters we have for today.
Thank you. Have a good day.
What does the state feel is appropriate on this matter?
Yes, Your Honor. In this case, we are asking for $15,000 bail, DAS supervision, as well as no possession of weapons, The defendant has a criminal history going back to 2022, where he had a domestic battery first conviction, where ultimately his probation was revoked in 2023, had a misdemeanor domestic battery second conviction in Reno Justice Court in 2023, where he failed to appear for a review hearing in November of 23. He also had a battery on a protected person that was no issued in 2024, and then a misdemeanor conviction for possession of drug paraphernalia already this year. Given the facts here with the well, only the damage to the vehicle, obviously, it was a risk to many other property owners in the area. And given his failures to appear, we believe that he's a risk not to appear and a risk to the community, given that he did all this because he had, quote, had a bad day. So we believe bail is appropriate, DAS, and no weapons. Thank you.
Thank you, Your Honor. I believe that the $15,000 is not established by any of the evidence in this case. I recognize that he scores an 11 on the risk assessment. However, his criminal history only starts in 2022. I think that there are only 2 convictions, but I might be wrong with that, both for misdemeanors. In this case, we acknowledge that he has no job, no cell phone, and no home. We did reach out to Victory Outreach, where he was working with Jose, the Reverend. We were unable to get a hold of him over the weekend. I believe that an appropriate remedy would be for him to do an OR, daily check-ins with DAS while we still have it, and provide proof within 72 or 96 hours, as the court prefers, that he has checked in with Victory Outreach and is seeking at least their outpatient services, if not working on getting a bed there. On that, I submit.
All right, thank you. Based upon the defendant's NPRA score of a high risk to reoffend or fail to appear, the defendant's warrant in his previous domestic case with our court last year, his criminal history, multiple warrants in his case last year with this court. His criminal history, including this year with this court. The state shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant will be set as requested with conditions as requested. We'll see him back on the 7th for the filing of the criminal complaint. Thank you. Connor and then Price. State feels appropriate on this matter.
Yes, Your Honor. With Miss Connor, we are asking for $10,000 bail, DAS supervision, testing for alcohol and controlled substances, and comply with all CPS or Department of Human Services condition. Again, concerning in this case, given that it appears that CPS was already involved, the high PBT and obvious intoxication, she had a 2009 battery and petty larceny that I don't show a disposition for, and then a 2010 conviction in South Lake Tahoe for entering a non-commercial dwelling. Based upon, again, primarily the fact that it appears CPS was already involved here, and here we stand with these charges. We believe she's a risk to the community and to the children. In fact, as she appears unable to control her substance use, given the facts in this case, and believe that the bail and supervision is appropriate. Thank you.
All right, defense.
Thank you, Your Honor. Your Honor, we believe that there are less restrictive means other than monetary bail as required by Valdez-Jimenez to be considered. In this case, she does score an 8. Some of that was confirming job, residency, and cell phone. We have been able to reach out to a family member who confirms an address and the cell phone number. She is not currently employed. In looking at the CPS files that I was able to access, it appears that that is a voluntary safety plan with the children residing with their father and stepmother. She is not around the children, so that reduces the risk to those particular children. that was a different plan than had been assessed. I understand that that is a change, but the way to modify the condition so that she can be safely held in the community is to either require an ankle monitoring system with the 24-hour testing involved, or to require daily testing. That system could be installed before she leaves. That would modify any clear danger to the community. And with the information we were able to verify regarding residence and cell phone, that would drop her down to a 5, putting her in the area for an OR. And in this case, it looks like the only prior criminal conviction was a 2010 case referenced by the state, except that there is a Reno municipal case open. I was not able to access that file, but there is no hold from that system.
Looks like that's a traffic ticket, so I'm not sure she should be getting 2 points for that either. So if she's a low or low moderate, therefore I'm constitutionally compelled to release her on her own recognizance with random drug testing, daily alcohol testing, comply with CPS, obey all laws, make all court appearances, DAS supervision, November 10th. And 9 a.m. is your next court date. We'll see you back then. Price.
Make contact with the.
And then Saxton.
Being released, if they release the next 4 to 6 hours.
Okay, where's the court date?
Your Honor, Price with a P, correct?
Correct.
Yep.
Thank you.
All right, what state feels appropriate on this one?
Yes, Your Honor. In this case, we are asking for $5,000 as well as DAS supervision and testing for alcohol and controlled substances. Concerningly, for this defendant, he scores a 7, but he had another possession of a controlled substance and resisting case from May. I note that he was that case is still pending, that he had a pretrial violation report submitted by DAS that he never checked in after he was released, and that he was not actively being supervised. So here we have an individual who, in relatively short order, I guess 6 months apart, has 2 arrests for the same thing and has been AWOL from supervision. I think that gives the court some prior track record to say that he is a risk not to appear, not to follow those court orders. And so therefore we believe that bail is appropriate to ensure his compliance. Thank you.
All right, Cadet.
Your Honor, I would actually ask that we set an interim bail as requested by the state, but allow this to be readdressed after a mental health evaluation. Today, he is appearing in reds. We do also have information about fairly significant mental health issues. We were not able to confirm any of the information with his mother who lives in Pennsylvania, but we would be trying to do so. Given the totality of the circumstances, that's 7 on the risk assessment and the open case where we do have an attorney assigned, as well as the focus of the competency court in cases like this, I would ask for that interim bail at 10,000, but the ability to readdress. I know that's the exception to the rule, but I would ask for it in this case.
All right, bail will be set at $10,000. I'll mark it as interim. Random drug testing, DAS supervision, obey all laws, make all court appearances, November 7th at 9 a.m. is the defendant's next court date.
Thank you.
Saxton and then Kelly. You're welcome. What state feels appropriate on this matter?
Your Honor, I just double check that we don't have Tamara Hansen on the call at all.
I do not.
Okay. So Your Honor, we reached out to Ms. Hansen. Unfortunately, didn't hear back from her. We're prepared to go forward at this time. We notified her of the hearing today. In this particular case, we are asking for $15,000 bondable bail, bondable only. I understand it's category C, but given the violence against a person, we believe that the bondable is appropriate. We would ask for no contact with pursuant to NRS 178 with Ms. Hansen. The reporting party I'll list as LS, as I believe she's 17 years old, as well as the child, which I believe is also LS, who was also a witness, the child in common. Concerningly, in this case, well, one, it appears that alcohol has been an issue for Mr. Saxon for a while. Again, the PC sheet indicates that's what's going on here. And then he has a DUI conviction from 2010 in Sparks Municipal Court. He also had a domestic battery with this same victim. It appears, my notes are a little bit sketchy, but it appears that it was ultimately dismissed because the victim didn't show up at that during that case. I would note, though, however, that in that case, there was a pretrial violation report from August. So just about 10 weeks ago, it was August 19th, where sorry, that was a hearing. The report, I think, was from July, that the defendant was removed from the OSM that he had on the prior case due to non-compliance and was placed on random alcohol testing. And as of July, he had failed to report for testing since June and was not actively supervised. And so, again, concern given the fact that it appears that alcohol has been a lengthy issue was at issue in this case. And given the minors who witnessed this violence, we believe that he's a risk not only to this victim, but to the others in the household, having chased around the one child who said she was going to call 911. We'd also ask for a scram device, since how last time the OSM did not work and he did not show up for testing. We would also ask for no weapons. And in addition to the 3 victims, we'd ask that the 1945 Margot Circle also be listed on that NRS 178 no contact. Thank you.
All right, defense.
Thank you, Your Honor. Your Honor, there were allegations that this, let me take a step back. In this case, Mr. Saxon does score a 5 on the risk assessment. Points for employment, residence, and cell phone. We were able to call his father, Dana, who lives in the area. Mr. Saxon can stay with Dana at a 2135 Inca Dove Court. He also confirmed employment for Mr. Saxon at Summit Fire and Security, where he's been at for 8 months, and confirmed a cell phone number. With those in confirmation, this would put Mr. Saxon at a 3. We were able to look at that domestic battery from 2025 that was dismissed, meaning the only prior conviction, I think, was 2010. Mr. Saxon would agree to all conditions except for monetary bail in this case, which I don't believe has been proven as the only way of securing compliance, given that there is a scram, a separate residence, and the risk assessment on that NPRA is lowered with the information we can confirm. We would have no objection to a stay away and a no contact order. He understands what's going on. He, in fact, wants to get into substance abuse treatment. And in this case, in addition to the scram, if this court would require setting up outpatient treatment until an inpatient assessment can be done, Mr. Saxon would agree. He would also agree to do peer counseling, such as AANA, or a religious-based counseling program if the court would make that an order. He just wants to get out to make sure that he can continue working and continue supporting his family, himself, and given that there's a safe place to do it in that lower score, that's what we would request.
So those are, I think, very reasonable requests. But largely what we attempted to do already this year with the same victim, with the same juvenile reporting, in that case, that the defendant had punched her mother in the face with a closed fist. And the defendant was not successful pre-trial with those conditions. And so therefore, the defendant's behavior is shown by clear and convincing evidence. The bail is necessary to ensure the safety of the community and the appearance of the defendant. We set at $25,000. There is no evidence that bail bondsmen in any way protect the community or ensure that defendants appear. So there's no reason to do away with the 10% option that is the best recognized practice. Again, there is no best recognized practice that supports bail bonds. No contact with the victim, separate criminal offense pursuant to NRS 178.445, and we will add that address. Daily alcohol testing in place before release. No firearms. Check in with the resort of bail laws, medical court appearances, daily mutual support group meetings until in treatment. November 7th, the 9 a.m. to the 26th court date.
Down here, it just says you're gonna make contact with
Kelly.
police 4 hours vehicle arrest.
After Kelly is Lawrence.
So $25,000 out there. It's when you are released.
And Your Honor, just in advance, Mr. Kelly did indicate on his paperwork that he will,
He was gonna hire his own attorney.
yes, Your
Yes.
Honor, we would ask to be assigned for the purpose of today's hearing only if you'll allow.
And Your Honor, if I may, I was going to ask for additional time to contact the victim. Because she's still in the
See you
hospital.
tomorrow, Mr. Kelly. And Mr. Kelly, I don't believe the law allows for me to appoint the public defender if you're not indigent. It does if you have severe mental illness or there's some sort of emergency involved, but that's the only time the statute allows me to do it. And so you're gonna have a choice tomorrow to either represent yourself or try and hire an attorney to be here and request a continuance for them to make their appearance. We'll see you tomorrow either way. Thank you.
All right, Kelly, you get it back on.
Lawrence and then Macias.
And Your Honor, I'm just checking, was Preston Tomsu released?
Yes.
Thank you.
All right, let's see if it feels appropriate on this one.
Yes, Your Honor, we're asking for 5,000 bail, DAS, testing for alcohol controlled substances. Defendant scores an extremely high on the NPRA. It's got history going back to 2016. However, I think the last couple years are most instructive, that he has multiple misdemeanor convictions and failures to appear. So I'll just start with 23. He had a possession of drug paraphernalia in Sparks Justice Court, then had a failure to appear conviction in Sparks Municipal Court, trespass conviction, Sparks Municipal Court, possession of drug paraphernalia, Sparks Justice Court. Then in 24, he had a failure to appear arrest, a petty larceny conviction in Sparks Municipal Court, a false statement obstructing misdemeanor conviction in Sparks Municipal Court, trespass conviction, Sparks Municipal Court, a possession of stolen property, Sparks Municipal Court, a failure to appear arrest, a trespass and failure to appear arrest. It looks like it was ultimately dismissed. A misdemeanor conviction for battery in Reno Municipal Court, a possession of drug paraphernalia conviction in Sparks Justice Court, a failure to appear arrest this year, a misdemeanor conviction for trespass in Reno Municipal Court, as well as a misdemeanor conviction for obstructing in Reno Municipal Court, and then another failure to appear arrest. And so given the again, just the dismal performance the last few years, we believe that bail is appropriate to ensure that he appears and takes care of this matter. And with that, I'd submit it.
All right, that's.
Thank you, Your Honor. Your Honor, we know what we're up against. He is hopeful for a pretrial release. That 15 does make it look bad, but I think one of the things that we discussed is you never know where bottom is. Mr. Lawrence believes that this is the time that he will change. He is hopeful that this court will allow him the opportunity to show the difference. He does struggle with homelessness and substance abuse. The behavioral health crisis of addiction is not best cured in Washoe County Jail. However, he acknowledges that 15, if the court is unwilling to give him an OR, I would ask you to consider IAP to inpatient.
Mr. Lawrence, you are going to have your chance. It just may not be today, because your prior criminal history, the state has a compelling governmental interest in making sure that you do not reoffend and make sure you appear. So they are entitled to have bail set in this case in the amount of $5,000. You'll have random drug and alcohol testing. I will release you to residential or inpatient treatment if that is what a evaluation recommends with IAP to assist. DA supervision of bail laws make all court appearances November 7th at 9 a.m. Your next court date. We'll see you back then. Macias.
Okay, yes, I'm 4 hours business.
And Your Honor, as Mr. Macias is making his way, this is another one where we are asking for additional time to contact the victim in this case.
All right, we'll see you tomorrow, Mr. Macias. Is there anyone else up at the chair?
No, there isn't, Your Honor. Thank you.